There are two kinds of garnishments. One is a garnishment of earnings, and the other is a garnishment of non-earnings. And so if a lawyer has a judgment against you and he knows where you work, more likely than not, he is going to apply for a writ of garnishment of earnings. If the writ is granted, he serves it upon your employer, and he is entitled to 25% of your disposable income, with disposable income being determined by the Arizona garnishment statute. And so that's a writ of earnings. It's 25% of your take home. If you apply to the court to have that reduced to 15%, most of the time it will be reduced to 15%. And we can show you how to do that and help you with that if it's necessary in your case. A writ of non-earnings is when a lawyer with a judgment applies to the court and says, "Judge, I want to attempt to take money out of this debtor's bank account. Please give me a writ. I'm going to send it to the bank. And if they have money in their bank account above the exemption amount in Arizona, I think I'm entitled to it." So that's a writ of non-earnings. It's just money sitting in the bank account. And so they also have the opportunity, a writ of non-earnings can attach property. So anything that's non-exempt in Arizona could be attached. Real estate, cars with values that have equity values of more than $6,000. But what I want to impress upon you in this video is that writs of non-earnings are very risky for creditors' lawyers. We don't see them very often, but when we do, we know we have a very aggressive creditor's lawyer on the other side, and more likely than not, it's time to file a bankruptcy petition.